So we jump back into Richard Morgan Casey's evidence to the Post Office Horizon IT inquiry, and he's shown an attendance note from a conference that he attended, which suggests that Mandy Talbot from the Post Office regarded the Lee Castleton case as almost some kind of test case, and that a number of other Post Office cases, that other solicitors were waiting on the outcome of the Lee Castleton case to see how to approach their case. But Richard Morgan Casey insists that he didn't see it as a test case. He wasn't instructed to run it as a test case, and therefore he wasn't out to run the case in a certain way to prove specific legal points. Let's jump into the inquiry.
Can we move, please, to page 15 of your witness statement at paragraph 49? So page 15, please. And paragraph 49, you say, I've absolutely no idea why or by whom the Castleton case was considered a test case. Although I note Mandy Talbot apparently said it had, quote, almost become a test case in spite of itself in an attendance note of the 11th of September 2006. As far as I was concerned, it was a single case to be decided on its own facts, as with every other case. I didn't adjust the issues to run it as a test case, nor was I asked to run it as a test case for anything. I was only ever instructed to bring a claim to recover amounts owing. The case wasn't presented to the court as a test case, and in my view, the judgment doesn't read as if the judge treated it as a test case of anything.
But the Post Office clearly considered that, because we know that a flurry of cases followed this and only gained in intensity until they actually stopped in 2019, long after issues had been raised, certainly internally at the Post Office, with what was going on with Horizon.
And so, reading that together, it was your view that this was not a test case in any sense of that word, or those words, for the Post Office?
Yes, it was a single one-off case.
Well, it would have been bad enough if it had stayed as that, but it wasn't in reality as things went forward, was it?
Can we look, please, at poll 3069622, which is the attendance note you refer to there? This is a 6-page attendance note of a conference held with you, 2 solicitors from Bond Pierce, and a number of the witnesses that the Post Office was going to use at Mr. Castleton's trial.
Yes.
It's at your chambers. And if we just go to page 5, please, and look at the end of the document. Thank you. Meeting with Mandy Talbot. Tom Beezer, I think, explained that the big issue in this case was proving the loss. Horizon is like a big calculator, and it can be changed after the event. Tom went on to explain why. Just thinking back to the answer you gave about the issue of whether you got an answer to the reasonable question you asked, can the system be changed after the event? Presumably you don't now recall receiving this explanation, nor indeed what the explanation was.
No.
Horizon is like a big calculator, yeah, a big calculator with all the buttons switched around by the sounds of things.
And again, thinking back, do you think this played any part in the strategy of deploying a nice legal point? That there were actual real difficulties on the ground in proving a loss?
I don't think I do recall this playing any part, because I just think the sequencing is wrong. I think I'd already taken the decision by that stage that it needed to be by way of settled account or account stated. I thought, look, it's such a long time ago, but my feeling at this remove is that that decision, or my advice, was given in August, and that it then sort of rolled forward.
At the foot of the page, Mandy Talbot said the difficulty is this has almost become a test case in spite of itself. The Post Office, other solicitors' cases are waiting and watching on this. And then it turns to consider settlement. Did you know of any reason why Mr. Castleton's case might be singled out as a test case instead of other cases involving allegations that there were issues with the Horizon system?
I don't remember knowing any at the time, no. I don't know any now, and I don't remember knowing any at the time.
Would you expect a client who viewed their case to be a test case to ordinarily inform you of that fact so that you would have knowledge of it when conducting the litigation?
In my professional experience, the only occasion on which a client has told me that a case is a test case is when it's been a government department. And government departments then ask for particular arguments to be run in particular ways so as to achieve a result that is useful for other cases. And I have not been lead counsel instructed on those cases. I've been acting as junior to the Treasury Devil. So I've seen it happen. I've seen it happen for government departments. I've never experienced it for a commercial client, and the considerations are rather different.
Do you now recall what you made of being given this information?
Given what information?
What's recorded at the foot of the page?
No. Should I?
Well, one would think if you didn't regard it as a test case, you might say, hold on, it's almost become a test case. I don't think so. Test cases, in my opinion, have only ever been brought in cases of government, and that's where they ask us to run specific arguments in specific ways. So this can't be a test case, Mr. Post Office or Miss Post Office.
What effect would that information have on you?
I don't think it would have any effect at all, because I don't think there was anything I could do. I had a case. My obligation was to run it to the best of my ability in accordance with my instructions. But my instructions weren't run it in this way so that we get a precedent to achieve X or Y or Z. My instructions were there is a debt of £25,500 odd pounds owing by Mr. Castleton on the basis of what's shown for his branch. Please take the claim to trial. It wasn't. A government department would say, please take the case to trial and achieve this result on the basis of these arguments. That was my discretion as to how the case was put at trial, was never circumscribed.
I see. So you weren't given instructions to try and establish a legal point?
Yes, that's right.
And you weren't given instructions to try and establish the integrity of the Horizon system, either A, insofar as it works in the Marine Drive branch, or more generally?
Exactly. And indeed, had I been asked to do that, I think I would have given them a pretty succinct answer as to why I wasn't going to do that and how I couldn't do that, particularly not on the basis of the evidence that I had.
Well, also, such an approach would be inconsistent with your primary strategy of proving the case on the account.
Yes.
And so I'm asking you, what became of this? You've got somebody saying to you here, an important person within the post office, this has become a test case.
Well, she doesn't. Sorry.
Well, okay,
there was a conversation in a conference in September of 2006 at which Mandy Talbot was present. Mr. Lister or Mr. Beezer or whoever it was took an attendance note and recorded something that may or may not have been said within that conference.
Well, surely they wouldn't record something that wasn't said. Otherwise, that's not a very accurate attendance note, and you can't really then suggest that you can rely on anything in the attendance note. Presumably it's recorded because it was said. Whether it was right or wrong is another question.
I don't remember her using those words, but there again, I don't really remember the meeting at all. And almost become a test case in spite of itself. If those were the words used by Mandy Talbot, they don't. If I was cross-examining, I wouldn't be putting it to the witness that Mandy Talbot was saying that it should be run as a test case. It's more of an observation by an individual as to what she thought was happening to the case. But there we are. I mean, I just can't assist you as to what she thought she was saying, why somebody's seen fit to take a note of it, or what it means. But it certainly didn't impact upon what I was doing.